Lordship. It is matter after 2 weeks, Lord.
21 and 20. The opposite side is here.
Yes, education department. Yes, yes.
Council put their time. Wait for time. The other side has no objective. List up 2 weeks.
Obliged.
Lordship, may I please for listing of a writ appeal, Lordship? On the first day itself, Lordship, direction was issued for hearing of the interim prayer, Lordship.
For
Hearing on
of the interim.
yes, Lordship.
Is there already a date fixed by the office?
Next date has not been fixed, Lordship.
It's
Last
not
it
been-
was listed on 17/1. I am praying for listing because one contempt case is pending, Lord.
The service has been completed. What is the state?
Service has been complete, Lord.
All right, it is listed on Thursday. Thursday is fine.
Lordship, Lordship. Obliged.
Made to them. And I beg to mention item number 26, madam. I have taken consent of the other side, madam. The matter will be taken up after 2 weeks, madam.
Council to the plan. Please type. The other side has no objection. Please come to me.
Obliged, Lordship.
From henceforth, we are issuing a pro forma for adjournment. You will get it by evening. So whosoever wants to make a request for adjournment, he has to circulate that adjournment slip a day in advance.
Obliged.
May I please, your Lordship. Lordship, with concern of the other side, I beg to mention item number 48 of the daily list, my Lord. Here, my senior Mr. P. Monto has been engaged as the amicus curiae, my Lord. He has some personal difficulties today, my Lord. May I the matter will be taken up after a week, my Lord.
Yes, wait, fine. Property council. Please come.
I love Lordship.
My lord, one WCC criminal I have filed on 6/2/2023. Till now, matter was not listed. So, my lord, my humble prayer tomorrow.
What is the matter about, ma'am?
Matter, my lord, I have already two similar order, my lord, passed by the division bench, and accordingly, I have filed this WPC criminal. Subsequent allegation.
WPC.
WP criminal, my lord.
That is the small one. Taking a request here.
WP criminal, my lord. The petition criminal also.
So there is one.
Habeas corpus, my lord.
All right, get it listed on Thursday
Next date, my lord.
as per roster.
May it please your lordship, with the consent of the other side, I beg to mention item number 16 to 6 to 14.
6 to 14.
Yes.
Sir, these matters you are supposed to make a request in advance. What for have you read the files then? Why adjournment? What is the reason?
Lordship, today I have some difficulty assisting senior counsel, lordship.
You're a young man. You had the entire weekend at your disposal.
I have some difficulty to assist learned.
It is not
general.
fair actually. You should at least have the courtesy to inform the court in advance.
Apology, lordship.
When do you want?
Lordship, on 2nd of March.
As prayed by counsel for the appellant, re-notify on 2nd March.
Obliged.
May it please your lordship. Lordship, in item number 34, lordship will file an additional affidavit, lordship. So this record may be called for lordship at the time of calling.
You have filed an additional affidavit.
Yes,
You
your
want it to be tagged with the file.
yes, your lordship.
Counsel for the appellant states that she has filed an additional affidavit on behalf of the writ appellant. The registry is tracked the same with the file and lists the matter after
No, lordship, today it's
today
the
itself.
matter
तो
call
बुला लीजिए, मंगा लीजिए.
at the time of listening.
Yeah, sure.
I love it.
May I please your lordship? Your lordship, I would beg to mention item number 58 as my senior Mr. J. Roy, learned senior counsel appears for NRL. The respondent, your lordship.
This matter will not be heard by my Lord's Honorable Justice Suman Shah. So we'll pass that order. This is for a bench of which my Lord Honorable Justice Sham is not a member.
May I please your lordship? With the consent of the respondents, I beg to mention item number 45, lordship. Can we kindly adjourn for a week, lordship?
This appeal is against which judgment? Judgment passed by whom?
Family court, lordship.
Family court, are you sure?
Yes, lordship.
Okay, very well. List of 2 weeks as prayed by counsel.
Obliged.
No,
May I
Yes.
please, your lordship? The consent of the other side, I beg to mention item number 49, lordship.
49.
Lordship.
Yes,
Kindly
please.
adjourn the matter for a week, lordship.
As prayed by counsel for the appellant,
Lordship.
list up 2 weeks.
Highly obliged.
May I please your lordship? Lordship, I beg to mention item number 2, lordship. Lordship, in this petition, lordship, we have to withdraw lordship with a leave of this honorable court to file a fresh lordship. I have taken consent of the other side lordship.
This is just item number 2 and you are seeking adjournment. Really? All right. You want to withdraw?
Withdraw lordship with liberty to lordship file a fresh. There is some
Counsel for the petitioner craves liberty to withdraw the instant writ petition within bracket PIL with liberty to file a fresh one if so required.
lordship. Obliged.
Accordingly, the instant writ petition is disposed of as withdrawn with the liberty paid for.
May it please your lordship, lordship, with the consent of the other side, I beg to mention item number 53, lordship. Can it be taken after 2 weeks, lordship?
4 weeks.
2 weeks, lordship,
2.
lordship.
You are for the
Applicant, lordship.
counsel for the applicant. Then counsel for the applicant prays for time. The other side has no objection, list up to 2 weeks.
Oblige your lordship.
May I please, your lordship? I beg to mention item number 5. We are filing affidavit in opposition today. So it may
The
come up-
entire first page is gone, sir. What do you want to
We are
file?
filing affidavit in opposition today.
Affidavit.
Yeah, we are filing.
So all right, let the affidavit come, we'll consider it, take it up.
Yes, after a week. I've informed the other side.
Counsel for the petitioner prays for submit that he would be filing an affidavit during the course of the day.
Yes, Lord.
This is a matter arising out of surfacey proceedings.
Lordship. And already the matter is pending in the Gaps Recovery Tribunal.
It's pending before,
Gaps Recovery Tribunal.
then why writ petition is maintainable?
This read is filed because the principle of natural justice has been hit. That is the main thing.
The DRT has the jurisdiction to decide even those
My-
issues.
My lordship, there is the judgment also, if the principles of natural justice has been hit, the High Court have also the jurisdiction.
Lordship, the main plea before you, the filing the surface application at the relevant time was that in page that the DRT was not functioning at that relevant time.
Now it is
No,
functional.
it has been functioning and there is it is functioning.
Lordship, no,
And after that, they have filed
Then why you are seeking adjournment, gentlemen?
then
Why you are seeking adjournment? Let him argue.
No, I am placing affidavit in opposition on record. That is why.
These facts are not disputed. All right, when do you want? Counsel for the respondent, place for time. List on 2nd March.
Obliged.
I would like to mention item number 59, your lordship, read appeal number 158 of 2021, your lordship. I'm appearing for respondent number 1 to 10, your lordship. I'm Ranjit Prasad, your lordship, from Sikkim, your lordship. I'm coming. And your lordship, we have filed one placing on record application to e-filing, your lordship, if your lordship allows to be tacked on the next hearing date.
You're filing something today.
On 18th of February,
You have filed something.
e-filing through
What
e-filing.
is, okay, that's
Placing
wonderful
on
to know
record document.
that you have filed some through e-filing.
Yes,
That is the first time I have come to know that some e-filing is also being done here. A good news. All right, so you want that, it has still not been tagged as per you.
not tagged because subject to defect clearing, your lordship, it requires
Is there any defect in your application?
no lordship, it is
Find
under
out first.
scrutiny.
Find out first why his application has not been tagged. If there is an attempt to e-file, it has to be encouraged. There seems to be a rarity. We need to rectify that.
Grateful lordship.
Just wait for a while. Let us find out why your application has not been dealt by the registry.
lordship, the slip here reflects that court fee is not paid. In the filing
Court
slip.
fees is not paid.
Lordship.
Yeah.
For that
Was it-
purpose,
Yes, your lordship.
Pay the court fees by
We will
e-process again.
cure the defect in the course of the day. your
All right,
lordship.
counsel for the respondent submit that he has submitted an application through e-filing process
E-filing. Yes, sir.
and some defect has been pointed out by the registry. the same be cured
Cured
during the course of the day?
Your Lordship.
List on, when do you want?
The month of May, Your Lordship, for final hearing. Final
So
hearing.
when do you want?
May, any date.
Why May?
Because
There's only one matter listed.
Yes, Your Lordship.
Lordship, I'm appearing for the AAG Sikkim, Your Lordship.
Mhm.
Lordship, she's having some difficulty, medical difficulty, Your Lordship.
Okay. So all right, you point out the date when you want the
15th,
matter to be fixed.
15th of May.
15th May as per.
Grateful, Lord. Grateful.
May I please your lordship? Lordship, I beg to mention item number 43 and 44 in lordship. Kindly adjourn for a 2 week.
Half of the list is gone, madam. 43 and 44. We'll have to put a cap. No,
Actually, lordship, my senior is out of station for some medical difficulty.
okay. Counsel for the petition. This is a contempt
Yes,
petition.
yes, lordship.
We have to see the response of the respondents. Let it be called out. Wait for your turn. Okay, we'll see. If there is a necessity to adjourn, we'll do that.
May I please, Your Lordship? Lordship, I beg to listing of a urgent listing of a writ appeal, Lordship, on Thursday, Lordship.
What is the matter about?
Your Lordship, matter related to that teacher's qualification, Lordship.
Technicians qualification.
No, Lordship, teacher's eligibility test qualification.
Teachers
Yes, Lordship.
qualification. When was the single bench order passed?
Lordship, on 2022, Lordship.
That you were so very eager to get the matter listed that you waited for almost how many days? What is the date of the impugned order?
Lordship, I have to check it out, Lordship.
Oh,
Last year it was.
gentlemen, that is not done. You're not aware of anything and you want the matter to be listed urgently.
No, Lordship, actually, the government is already giving appointments, Lordship. And this,
Okay. What is the sense of urgency you have shown?
Lordship, the respondents are, they could not give any.
All right, get it listed on next Monday.
Obliged.
Hey, please, your lordship. Lordship, I'm sorry, I'm praying for an adjournment in item number 47, lordship. I'm appearing for the appellant's lordship. Hearing lordship, a senior advocate, Mr. PC Das, will be leading me, lordship. He will be arguing this matter, but he has met with an accident.
Oh.
So if lordship pleases to adjourn the matter for this week, he will be resuming after 24th, any date after 24th.
It is stated that there is a personal difficulty for learned senior counsel, Shri Das, as he has met an accident. Prayer is made to adjourn the matter, re-notify on. When do you want?
Lordship, any
Your
date,
2nd March.
second. Obliged, lordship.
I know. Yes, please.
Right, please, your lordship. It is a habeas corpus application, my lord. And here, my lord, the purpose, my lord,
The other side wants to controvert a secondary school certificate by a simple birth certificate. Kindly read section 94 of the JJ Act. Is there any discrepancy at all? JJ Act, DG. You can take your seat.
my lord, problem.
In the section. Let it take that. The order of preference is arranged in a sequence. Please read that, sir. The girl who is major is lodged in the home against her wishes. For how long? Lead, sir, 94.
Lordship.
You are having JJ Act, sir? Juvenile Justice Act, are you having, sir? Are you carrying Juvenile Justice Act with you?
No, Lordship.
No. Please provide, sir. Assist Learned Counsel. Kindly read section 94.
Where it is obvious to the committee of the board, based on the appearance of the person brought before it under any of the provisions of this act, other than for the purpose of giving evidence that the said person is a child, the committee or the board shall record such observation stating the age of the child as nearly as may be and proceed with the inquiry under section 14 of the section or section 36 as the case may be without writing for further confirmation of the age.
Now, sir, please read subclause 2. There is an order of preference given out regarding which document will have the more evidentiary value regarding decision determination of age. Better evidentiary value. Please read, sir. 2 subclause 1.
Yes, madam. The date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board, if available. And
in absence thereof. So we need to go clauses 2 and 3 only if the date of birth certificate from school is not available. In this case, the school certificate was available right from the day 1.
a lot of people kindly consider that in the Aadhaar card also, same date is made, which comes from the school
Sir, do
certificate.
we need to at all look at the Aadhaar card in view of the specific provision contained in law? Please cite any judgment which says so, that we can rely on the Aadhaar card for determining the age.
But in this particular case, my lord, the facts are such. The parents say that the age
Sir,
is.
please, law, we are talking only of law. This is a writ petition, habeas corpus, dealing with the liberty of an individual. So what is the position of law?
My lord, as yet board has not been constituted and no age is.
Board.
Right.
What does the board have to do with the determination of age? Assuming that she's a child, she is a CNCL, right?
Lordship,
Child in need of care and protection, CNCP, child in need of care and protection.
lordship,
Which is the body competent to decide her age, determine her age?
my lord, my humble submission, first the parents, my lord.
Sir, which is the body having jurisdiction, the authority having jurisdiction in law
To my
to
lord.
determine the age?
Lordship.
No idea.
Yes.
Please let us know.
My lord, I am pressing the judgment. It is bill appeal number 3615 of 2009.
Judgment of this court.
The Supreme Court.
Yes, please read what has been laid down in that judgment.
Yes, my lord.
Presumably that judgment relates to the year when Juvenile Justice Act was not in force.
Entries made in terms of statutory provision shall prevail over the entry made in the school living certificate, particularly when the details of dates of birth of the brothers and sisters of the respondent has clearly been provided by the chief officer.
Sir, the earliest judgment on this issue was Biradmal Singhvi versus Anand Purohit, dealing with section 35 of the Evidence Act.
Sure.
But we have come a long way thereafter. Now there is a specific law governing the field, which is the Juvenile Justice Act, which is the only law which we need to refer when we are going into the determination age of a minor. And the first question which we put to you was, how do you answer this query regarding date of birth as mentioned in the matriculation certificate having a greater evidentiary value as compared to any other document or any other evidence? Please answer that.
My submission is that whatever date is put in the school living certificate, they have to get it from some source. And it was the date they got from the last school attended by the
You are questioning the validity of the school certificate, right?
lordship.
Then the burden is on you to controvert that entry. What evidence have you put to show that the school age in school was not recorded faithfully?
Lordship, defined schools have given defined date of birth. The school from where she passed the higher secondary, it also gave one date. They had no source to show where from they got that.
Who gets a child admitted?
My lord, that is also under controversy because at times the school authority has said that it was given by the child herself and on other occasions by the parents. So it requires an inquiry.
So the query goes back to the same situation, point one, how to controvert that certificate. In absence thereof, only the law says that you have to fall back on any other evidence. Your own, that age certificate, there is a report of the concerned officer that there is no corresponding entry in the record. So that itself is a fabricated one, the one which you procured in 2017.
They are also, lordship, humble submission. The person concerned appeared before the honorable court. Nothing was recorded and he was allowed to go. From her statement, it was clear that the same system is followed with regard to other cases also where other certificates are also issued. So that is not such a big fault, lordship, for which that can be discarded.
All right, sir. Anything else to say?
Lordship, and only now I have come to learn that the girl who is still in a stay home, she has expressed desire to come to the parents. She has given something.
She is major. We will set her free. She is free to proceed wherever she wants.
No, my lord. The content is such that she has written that when I attain majority, I will marry the boy of my choice. But till
Sir,
that
she is
time,
already major. In case of a major person being detained in a home without any reason, the only direction which this court gives in habeas corpus petition is release the person forthwith. The person is free to proceed as per his or her own desire. So there is no question of guardianship being granted.
my lord,
That will be the order.
my lord, now the petitioner in the writ petitioner, if herself says that I am minor and till attaining majority, I'll.
Okay, sir. Understood. Thank you. State Council, why has the CWC not determined the age? Mr. Council, JJB is no one, has no authority, and she is a CNCP. CNCP, the only jurisdiction is with the CWC, sir. CWC was required to do it at the first instance. We'll let you know of an order which we passed in Rajasthan. There was a similar matter. The CWC chairperson detained the girl beyond her attaining the age of majority as per the school record. We not only directed her release, we imposed cost of rupees 50,000 on the CWC, and the order was affirmed by Honorable Supreme Court. This is a case of gross illegal detention. No. All right, that petition around the detaining shall be released from custody forthwith. Will dictate the order in chambers.
Highly applauded. Matter number 3.
This in this case, my lord, that the petitioners taken loan. The petition is a mortgage of the property.
Yes,
Petition is a mortgage of the property, and the property was auctioned. That house was auctioned, which belongs to her, and that that all the articles which was when they are in possessions, those were not handed over to the petitioners while they are auctioning their property. So in spite of our repeated request, they have not returned back our property because we have given a list and they have admitted their other properties. Instead of,
I have received instruction, my lord. I need a week's time to file my affidavit. We'll clarify the entire position.
Should we give them a week's time?
my lord,
Maybe you will not need to seek relief from this court. They might agree to your submissions.
my lord, no, I have no objection, but in them, they should not carry out further.
The property is sold, the sale certificate is issued, the purchaser is in, my lord,
In possession already.
possession.
All in position.
That's
So
all.
the remedy for you would have to be approach the DRT.
No, DRT because we cannot approach the DRT because we are not challenging the service. We are not challenging the service. Neither we are challenging service, nor we are going against any order.
Then
We have only
what that your articles which are lying in the property,
yes,
that they should be returned to you.
yes, my lord.
There must have been an inventory prepared.
Yes, inventory has been-
Let the bank
Lordship.
give its response.
Look. Take angle for the bank.
What?
Any fixed date will be given, my lord? Any fixed date?
Give it 2nd March. maybe.
Second.
Item number 4.
May I please? My lord, the writ petition basically has been filed by a successful bidder in a contract for, my lord, stone quarry.
Yeah.
What had happened here was, my lord, he was given a provisional LOI.
Still. no. Yes, yes, please.
Why is it in the division page?
My lord, because what had happened here, I have challenged the provisions of the Assam
Of the act.
mineral concession rules 33, 3, 3 and 5 and also 22, 1 and 2. Why, my lord? Because in this particular case, the requisite permissions that are required from the concerned authorities were not obtained by the government, but they put them all to safe. Then a provisional LOA was issued to me, my lord, saying that you go and get these clearances. Now, I have proceeded before the authorities. The mining plan has been granted. Now, I am before the State Empowered Committee for Environmental Clearance. Now, I have approached them. They have also, my lord, recommended my case. Now, the authority is under, now the third stage has achieved. They are doing the public hearings. There is a process, my lord. This process will get concluded after they pass an order. They may reject it or they may grant it. Now, what they have done is, my lord, they have now invoked the provisions of the rules and said that because you have not paid the balance 15% and the dead rent, you are not entitled. We are cancelling your contract. Whereas, my lord, in the case on hand, an LOI, final LOI has not been issued, my lord. It's only a provisional LOI that has been issued, and I have been asked to move it, proceed further.
Yes, Mr. Counsel, your response is still awaited.
Well, I have taken instructions, my lord. There is no dispute.
Till then you don't proceed with the matter.
My lord.
You have to keep the things on hold.
My lord will kindly appreciate one thing, my lord. It is one thing to have an environment clearance mining plan, and it is other thing to make the payments in terms of the rules, which the petitioner was well aware of, my lord. He never deposited the money, my lord. He should have deposited the money. That is why we have invoked the provision. There's a deeming provision, my lord. It's a legal fiction created under a statute, my lord.
Right.
So if an order or impugn order is also not required, my lord. Because it says, my lord, if he fails to make the payment within time, it will be deemed that the LOI has been revoked.
LOI has been revoked. Okay. Till you file your response, counsel representing the respondents, praise for and is granted. How much time?
A week's time. 1 week time will do.
A week's time, file counter affidavit. And re-notify on. When?
Whenever it's second week of March, my lord.
Second week.
9th or 10th.
Or, come on. 14th would be okay?
My lord.
14th March.
My lord, the interim, my lord, may continue because he
The
has
interim
I have
order
given an
shall continue.
undertaking.
It's already an interim protection.
Lordship, that undertaking from my friend, that
Shall
I've
continue.
already given an undertaking. Much obliged, deeply obliged.
Item number 15.
Lordship, in this matter, I am filing the response today in the course of the day, Lordship.
How this is maintainable, madam? You are seeking parole for a convict who has been a person who has been convicted under the NDPS Act. Only the central government authority has the power to release such convicts on parole. Read a division bench judgment of Rajasthan High Court, Shambhu Dayal versus State of Rajasthan. This writ petition would not lie. You have approached the wrong authority.
But Lordship, in this regard, Lordship, my learned senior counsel will appear in this case, Lordship.
All right,
He would-
you have a look at that judgment. We'll
Lordship.
share the copy with you.
Lordship.
The counsel for the respondent prays for and is granted for state prays for and is granted a week's time file counter affidavit. List up to 1 week.
Obliged, Lordship, obliged.
Item number 16.
May it please your Lordship. Lordship, this writ petition has been prepared by the Union of India, being agreed by the order passed by the Land Central Administrative Tribunal, by which the charge memo against the issued against the respondent has been rejected first only on the ground of delay, Lordship. Lordship, the sequence of events has been stated in paragraph 9 of the petition.
The work for which the inquiry was initiated was
Lordship.
undertaken in the year 2005.
He was in the charge of the work 2006 to 2009, and the work finally completed in the year 2012.
And the
Lordship.
charge sheet served in
2017, Lordship, so cause was issued.
just let us know. How does he retain physical evidence of the work which has been done?
Lordship, in his, if your Lordship goes through his representation, he has not denied the charges. His only ground is that I was a first timer there. I was under probation, so I didn't have any experience. So it's a vast work spreading about a vast area. That was the ground he has taken. He has not denied the charges. And his ground is that since the third court of inquiry is pending, so it should, the outcome of some may be waited till then action may be taken against him. He had neither denied the charges, Lordship. And I'll be relying on the Lordship maxim that lapse of time does not take away the rights of the crown.
Antule, long lapse of time in initiating these proceedings makes the evidence disappear. The witnesses lose memory of the facts.
Yes, Lordship, the
So-
contrary is vigilantibus, that dormantibus, Lordship. That is also there, Lordship.
Okay, so now what is the matter for?
It has to be hard finally, Lordship. It will take some time, Lordship. May admit and fix for hearing, Lordship.
When
They
do
have,
you want, sir?
they have filed their affidavit, Lordship.
They have filed the affidavit. The court date may be given.
All right.
Court date, my lord.
Okay. Yeah. All right. On the request, pleadings are complete. On the request of learned counsel representing the parties, list for final disposal at the admission stage on 9th May.
Earlier, my lord. Earlier, he is not getting promotion also.
Promotion by
Two promotion
payment-
has
payment-
already been given.
Already-
during-
debit of 9th May. This is already out of the inquiry by virtue of the CAT order.
Yes.
Okay.
Oblige you.
Item number 17.
This is a appeal by the revenue, whereby Lordship petition was petition in the income of the petitioner was rejected by the both the Commissioner of Appeals and as well as the tribunal lordship. Lordship have submitted suggested sections.
There is an order noting in on 19th January that you were supposed to make some corrections.
I made correction.
You made the correction.
Yes, Lord.
Okay. Where are the substantial questions of law?
Lordship, I given
You have shared it with the opposite side.
Lordship. Your Lordship may just see substantial question of law.
Let him pass it on. So do you want to file some objection against these questions?
Your Lordship may just see
Their perusal will be
grounds on which he's challenging the order of the tribunal, which is at page 16. 6
Mhm. Page 6 of
of the appeal
appeal. Right.
Four
Yes, please.
Has your Lordship got it? The grounds for challenging the impugn order dated so and so by the income tax appeal tribunal is stated herein below. Now, in this case, the loose sheets having notification mark number so and so pertain to the SSC revealed that the SSC has sold shares during the year. It is found that the SSC liquidated investment in shares and converted into cash held in the bank. It has bearing on the determination of the income of the SSC. Therefore, prima facie, the satisfaction of the scrutiny was having incriminating information. It cannot be said to be perverse erroneous. Therefore, the decision of the ITAT is not acceptable. My lord, this is not the question, my lord. On the basis of this, only substantial question law arise. My lord, I may tell you, Lordship, my lord. Under section 153A, my lord, assessment beyond 6 years, 6 years, 10 years can be made only when incriminating materials about the assets beyond 50 lakhs are found. Now, in this case, my lord, when the such was made, the assessment has been made not on the basis of incriminating materials, something which was there already on the books of account under section 68, the addition has been made. Now, the tribunal came to conclusion, my lord, that the very new condition for making the assessment is that incriminating assets beyond 50 lakhs must be found and assessed. Now, in this case, since the incriminating materials was not at all there because he had not made assessment of anything outside the books of account, and thereby the preconditions of 153A is not fulfilled. Now, the grounds of challenge, it says about loose sheets and all those things. The tribunal having come to the conclusion on the basis of facts, the question of law is not there. You also may find that this is purely question of fact he's saying, and which has been dealt with in the so many words by the tribunal. The question of law can only arise on the basis of the grounds of challenge. It cannot be that any tribunal's order, anybody can frame the substantial question of law. Now we'll also see the substantial question of law which has been framed. That has no connection with the argument which has been advanced. It says the tribunal's order is not acceptable. Lord, tribunal's order is not acceptable.
Formal kind of question.
My lord, these are the questions which are framed. Just in the normal way, the questions have been framed. And if your lordship looks into the tribunal's order, you'll also find that it has been dealt with the CIT appeals as well as the tribunal. Both have dealt with the issue, and I found that no, the preconditions have not been fulfilled because no incriminating assets were found. And once the incriminating assets have not been found, the question of making the assessment beyond 6 years does not arise. So, the substantial question of law, only framing the substantial question of law, as your lordship is well aware, my lord, it must have the connection with the pleadings and the grounds of challenge. If your lordship looks into the grounds of challenge, it has no nexus with the substantial question of law proposed. And I need not place the judgments of the apex court as well as other judgments, that when the genuineness and all those factual things are there, then the question of law is not there. Your lordship be well aware of those. I don't want to burden. If your lordship wants to look into it, I just
pass on some judgment.
My lord. No, it was 1999.
Yes, Mr. Counsel, what do you say? Concurrent findings?
Lordship.
And even if you see your own substantial questions, suggested substantial questions, wherein you have not uttered a single word regarding incrementing information.
Lordship.
So if it is based simply on the basis of reanalysis, revisiting the facts already available on record, then where is the question of allowing proceedings under section 1?
Regarding incriminating materials in section 153, recently the hearing before the Honorable Supreme Court has been concluded and case has been fixed for judgment.
So you want us to wait for that judgment?
because that will clarify everything, because the same question of law was.
We can wait then, sir,
So the
rather than admitting it.
Well, I have no problem, but the apex court will not decide on the passing of the particular facts, but the incriminating materials are there.
Maybe let him have his own
Well, I
satisfaction.
have no objection at all. not
Because
your
Lordship,
lordship.
the same question of, heard by the Honorable Supreme Court.
You could have said in the very beginning that, the matter is pending, no necessity for framing the
Alright.
questions.
And counsel for the revenue pays for and is granted a week's time, 2 weeks' time, complete his instruction.
I am obliged.
Item number 18,
This is an appeal by the revenue. Lordship, in this case, the respondent, they did not deduct the TDS copy. They did not deduct the TDS from the services.
There was, Your Lordship. I have preliminary objection regarding the maintainability of the revenue. It's regarding forum convenience, Your Lordship. The Meghalaya High Court has a jurisdiction to enter in this matter, Your Lordship. There is a judgment of the Honorable Supreme Court, Your Lordship, if I may place that, Your
Lordship, that I have to check because it was filed in 2020, Lordship.
The court does not have jurisdiction. You have to seek a return of that petition and file it before appropriate.
Meghalaya High Court.
Lordship may take up day after tomorrow.
Your Lordship may kindly come to page 8 of the judgment, Your Lordship. Tomorrow. Definitely.
Lordship.
item number 19,
Please, your lordships. Yes, your lordship, the evicted persons are also rehabilitated. Right, yes, your lordship. I have filed an additional affidavit dated 15th of February, your lordship. Lordship, wide order dated 6/2/2022. Direction was issued by this honorable court to file an additional affidavit regarding the rehabilitation process of the evicted persons, evicted appellants, your lordship. So that has been filed, and lordship, if lordship has found the affidavit. Page number 116. This is a letter issued by the circle officer. Lordship may dispose of this written.
Sorry, my lord. I have an appeal.
There's nothing in it. Already eviction has happened and you have been rehabilitated.
Yes, my lord. But they have submitted an affidavit, my lord. Lordship may peruse, my lord, earlier order of this honorable
So
court.
what is the relief you want now? You have already been evicted.
Yes, my lord. They wanted to, my lord, allot some land, my lord.
Your
They
case
have
was,
been rehabilitated. That is what the affidavit dated 15th February says. You have not countered that affidavit.
My lord, only what is the language, my lord, in that affidavit, my lord? They have shifted, my lord. But
Mr. Counsel, your basic grievance was that your application for settlement is pending.
yes, my
Will
lord.
not be evicted.
Yes, my lord.
You've already been evicted,
Yes, my
Yes,
lord.
your lord.
and that planet single judge rejected your prayer.
Yes, your lord.
What
Yes.
is there? What is the live issue to be decided?
My lord, there are some other issues, my lord. What happened, my lord? They have taken the policy on, my lord, pick and choose policy, my lord. What happened, my lord? Till date, my lord, about more than 20 families are there in the same land. But they have ousted us, my lord. I have
This is not a
Oh.
PIL.
always, my lord.
Talk about your right.
What happened, my lord? And only that for the proposed marriage building, only required 10 bighas of land. My lord, they are evicted, my lord, about 34 bighas of land, my lord. So, my lord, they can, my lord, constructed everything, my lord, without evicting us.
Gentlemen, it is a fact that your clients were encroachers. There is no
Yes, your
dispute
lord.
about that.
Yes.
So an encroacher has been evicted and rehabilitation has been done. What survives?
Yes, my lord, only rehabilitation I am agree, my lord.
Then
But rehabilitation I am agree, my lord. But what they, only they have taken their affidavit, my lord. They have shifted, my lord. The language is they have shifted, my lord. It is not meaning that they have allotted us, my lord. They disclose that what kind of land given, how much land is given, where is given. That is not disclosed, my lord.
They have shifted to number 4 Chalia Chapuri village under the Biswanath Moza. It is there in the letter, Your Lordship.
Yes, my lord. That is the language.
have been duly shifted, not they have been. That is the language. Then what remains? Sir?
There in the letter, Your Lordship.
And how much land is given, not as my lord. Only
They are encroaches, Your Lordship. It's up to the volition of the government.
Referred by the appellant. I told it that if it is so appellant being encroaches the government that did not capitalize. But appearance of the after the is the appellant of the government. Thereafter, they have location.
Yes, sir. Number 4 Chalia Sapuri village
That is
under
what-
Sapuri village under Biswanath Moza in Biswanath Revenue Circle.
From the applicant. The applicant. There is no dispute about that. The applicant. But that. We do not find it.
But-
At this point.
but my lord,
I'm deeply obliged.
my submission is that, my lord, till date, my lord, no land given to us, only they have filed this affidavit, my lord. And the reply of the authority that as your case is pending, so without the decision of the court, we could not allow
They
to
have
them.
already
Others are
been
accepted, my lord.
resettled, sir. The affidavit says they have been resettled.
Others are
What else?
allotted, my lord.
That would be a separate cause of action. You file a PIL for that purpose. This writ petition was only against eviction. That process has been completed.
If you have any grievance, you are free to file independent writ. That your prayer in the earlier writ petition was something else. That is now over. All right.
Highly.
Item
I'm
number
deeply
20.
obliged, Your Lordship.
May I please, Lordship. There was an order passed by the GST authorities, Lordship. I had submitted details of the contracts executed by me regarding my pleading that entire turnover is exempted under the service tax law, Lordship. Without considering even my submissions in the impugned order, the order was passed levying 3.5 crores tax and equivalent penalty, Lordship. I had challenged the same before the learned single bench.
Statutory remedy.
No, but Lordship, about the statutory remedy, 7.5% has to be paid. So when my particular plea is that the entire turnover is exempted, Lordship,
You will get it back, sir.
if I am made to pay a sum of 50 lakhs, Lordship, that would cause severe prejudice to me, Lordship.
For that reason, can we entertain the writ petition, sir? That you will have to pay, make the statutory prepayment for filing an appeal.
No, but there
Would
is
the
an,
court be required to entertain your writ petition?
Lordship, there is an alternate remedy, but it is not,
That is a statutory remedy, not even alternate.
it is a statutory remedy, Lordship, but it is not an efficacious remedy, particularly when the entire turnover has been claimed to be exempted and details have been submitted at the time of hearing. Had it not been submitted or had it been rejected by the assessing authorities, that would have been a different case altogether, Lordship. But since he has not even mentioned about the submission of the details, this is a case of not following the judicial discipline, Lordship. So can the rule of alternate remedy prevail over the rule of judicial discipline, Lordship?
Sorry, sir. The remedy has to be availed. That is what the Supreme Court says in unequivocal terms.
But Lordship, then I would be deprived of the court of the first instance. He has not even gone into the facts of the case.
Then you have further remedies available. If the authority dismisses your appeal, you can come to the court for exercise of writ
But
jurisdiction.
then Lordship, the writ petition is only a self-imposed limitation. So if something palpable injustice is being caused to me, Lordship,
Have you got Justice M.R. Shah's judgment, recent judgment?
No,
No writ petition to be entertained.
Yes.
Where statutory remedies are available.
Yes.
Please pass on.
today, Lordship.
Not today.
No, I'll
It's a
provide
judgment
after
of, I think,
some time.
2022.
Lordship, I am
After
just
some
praying
time
for
I-
a remand to the assessing authorities. If it is remand, I
No,
get the
appellate
justice.
authority
Lordship.
has that jurisdiction, sir.
But that can only be availed by paying a handsome amount of money.
There is a mistake in the date in page 150. It is just 31/8/2022.
Yes, Lordship, there is a mistake. If it is remanded, Lordship, everything will get straight.
That would be virtually excising writ jurisdiction where remedy is available.
Lordship, I have annexed a judgment of the Honorable Supreme Court.
Let us see.
It is at page 190, Lordship.
190 is the impugned order, sir. The
Lordship,
second page.
No,
That's the judgment of 2000. Thereafter, much water has flown.
Yes, thereafter.
2005, Lordship.
2005. Much water has flown thereafter, sir.
No, but Lordship, something more has to be there to exercise the writ jurisdiction. So if the court of the first instance throws away my case without even considering it and relegates me to appellate remedy by
That is
payment
what
of
the
a money.
law of land says, Article 141. Binding precedents. Okay. Dismiss the limitation for filing appeal may be extended till for 30 days. Henceforth, sorry.
Matter number 23.
May I please, the Lordship? My lord, the matter herein, my lord, is regarding a TET examination, my lord, which has been conducted by the state of Assam, my lord. When these madrasa educational institutions, my lord, in the state of Assam were existing, my lord.
Can we make a small query? There were a number of writ petitions which were decided
My lord,
by the same order.
my
Whether
lord.
there are any other appeals?
No, my lord, as per my knowledge is concerned, my lord, only out of those batch of petitions, my lord, this is the only writ
Only
appeal
appeal which is
before my lordship. My lord.
very well.
My lord, my respected senior friend is insisting, my lord, for fixing the matter for hearing, my lord. As the respected AG is appearing, my lord, he has just submitted before me, my lord. My lord.
All right. When do you want, sir?
My lord, some urgency on our part, my lord, because a fresh recruitment drive has been initiated, my lord. And if we succeed, my lord, we may allow, be permitted, my lord.
Let us know the date on which
My
you
lord.
want.
My lord.
Matter to be heard.
On any date, my lord, in the last part of February, my lord. 27th, my lord. First week of March.
1st March,
My lord. Oblige me.
list for final disposal as jointly prayed.
My lord.
List for final disposal on 1st March.
My lord.
Matter number 24.
May I please, Lordship? As per your Lordship's order dated 3/11/2022, the Then council is supposed to bring the records pertains to appointment and the attendance register of the school.
I have received instructions today morning. Two issues, my lord. One, the principal, that time principal has made certain remarks on writing to us. Secondly, my lord, the entire records which is received by the office of the DO are not, are missing, my lord. And therefore an FIR has also been lodged with regard to that. My lord, these things I have to perhaps bring on an affidavit. I received the instructions today. Could it be after a week, my lord, where I can? That's my lord.
May I submit my? May I submit?
Mr. Majumdar,
My lord.
when did the appellant actually join in? Not
My lord,
the date of
the-
joining.
the appellant has provided two joining letters, one dated 10/4, one dated 10/4, my lord.
And before that, she did not.
My lord, no,
But-
she did not, she did not. Because the
That is not
principal says that the joining letter of 6/4, the date is not in his handwriting.
There is no
He
criminal
denies the
action
date.
so far. There is no criminal action regarding that.
My lord,
It
this,
it can't be that this issue regarding date not being in his handwriting
my
would
lord,
have gone unnoticed for almost 12 years.
my lord, this was a venture school at that point of time, and when the repetition came up, my lord, we were not in touch with the erstwhile principal. Only records which are available in photostat in the school were being produced to us. Now, my lord, when on my insistence, when we asked for the records, I called for the earlier principal to make his statement as to whom and where are the records. It is then he has made this statement, my lord, lordship will find on 15/2. I have the original in his writing, my lord, submitted to me by the DEO, my lord. So received today morning.
Evidence.
My lord, otherwise, matter can be, my lord. Matter can be looked, my lord, page 68. His own document has said he has joined on 10/4/2008.
That is right. There is a
Yes, my
discrepancy.
lord.
But the allegation is that she was made to, the appellant was made to sign a fresh joining letter.
And 68 is his document, my lord. Our document. And secondly, attendance register, my lord, what has been mentioned,
Yes.
2/4, he put the signature. On that day is the Good Friday, my lord. How can she put the signature? Has he tempered the register thereafter file a case before the honorable court, my lord? And he said that register should be considered. Register could not found, my lord. That is why learned single judge has categorically stated all these things. Para 7, 8, and 9, my lord.
My
And
limited
good
prayer
Friday
for
put the
the writ code is that there is a direction of this honorable court. There is page 42, my lord. The director is required to verify the attendance register of the school to while coming to the decision, my lord. The imperial order passed by the director.
Mr. Goswami, these read petitions are to be decided on the basis of materials and record.
My lord,
We can't go into what really happened. These are
My-
matters to be decided in a court which takes evidence.
my lord, definitely.
So
my lord.
what is the option for the writ appellate court? We always, and single judge is recorded of you. These are appeals in principle, in-house appeal. What is the material for us to reverse that fight? We can't reverse.
My limited prayer for the writ code is that there is a direction of this honorable court that page 42, the director, while passing the speaking order, my lord, take into consideration the school register, my lord, attendance register also. The director passed the impugning order without taking into consideration that order and passed whimsically the order, my lord, dated 28/6/2016. That is why I challenge that order before the writ court, my lord, single judge.
There is another observation by learned single bench regarding concealment of fact by the petitioner.
That is the statement made by the petitioner, my lord. Response number 5, my lord. My fact is that, my lord, there is a attendance
lord.
register. I put my signature in the attendance register.
All
And
the,
that is why page
all-
42 earlier, while dispose of the matter earlier, that is order dated 13/6/2013, page 41, it starts from, my lord. Page 42, paragraph 5, my lord.
Sir, please read page 87. Further to that, the petitioner having suppressed material facts which goes to the root of the matter is also not entitled to any equitable relief. So it is the
I am
petitioner.
aggrieved against this order. That is why I am before your lordships, my lord. There is a specific direction of this honorable court at page 42, my lord. Last part, my lord, paragraph 5, my lord.
Yes.
May I read, my lord? Page 42, paragraph 5, my lord. In view of the above discussion, the DSC, the director, that is Assam, is directed to determine the interest seniority of the petitioner and the respondent 5 by affording an opportunity to both the contender upon examination of the relevant document, including the school attendance register. A decision should be given on merit. The petitioner may furnish this order and her petition and so and so. My lord, here next page, my lord, 42, the order passed by the director. There is no whisper about
He
the,
is not supposed
my lord,
A record that he has seen, it is presumed
No.
that if the records are referred to in the order, they must have been seen.
There is
presumption regarding
there is
X
no
done in
no
discharge of
statement to that
official
effect,
duties.
my lord. There is nothing, my lord. The attendance history is not taken to consideration. That means the order passed by his honorable was ignored, my lord. That is why I before the learned single judge, my lord.
And you should have filed a contempt on careful consideration, after careful consideration and examination of materials on record. So that is what he is supposed to state,
My lord,
whether he's.
My lord,
the
direction
director was referred to-
was specific, my lord. Learned single judge, that is the attendance history is required to be verified. The director while passing the order, my lord, failed to verify the attendance register. That is my grievance, my lord.
Mr. Gupta. Come to page 44.
My lord.
See the paragraph we start from the above. This is the finding recorded by the director of the basis of an order of court, correct?
My lord.
The finding says both of them have joined on 10/4/2010.
My lord.
Show us something which goes to show that this finding is perverse. Is there anything on record?
My lord,
That is
my pleadings as well as my is that initially the appointment order was issued, my lord, on my lord,
60.
my lord, 5/4/2010. I placed my lord joining report on 6/4. Subsequently, that is a Vansa Institute stage, my lord. At my direction of the head of the institution, I had to work, my lord. The head of the institution instructed me to place another joining report on 10/4. That is my case, my lord. And on 10/4, another that respondent of 5 was joined, my lord. That is why the verification of the attendance register is very much, my lord. Let the government, they bring some record, let the
You
affidavit
would have
to be
procured
filed,
the
my lord.
evidence copy of the attendance register under the RTI Act. It is your own information to the authorities. Read on page number 82, sir. The said documents were furnished by the petitioner to the petitioner by the principal and secretary of the so-and-so school on 24th March 2015. Amongst the various documents so furnished, one of such documents was the individual information to be furnished by such employee. The document was a document furnished by the petitioner on 9/2/11, wherein the petitioner had against the column number 7, date of joining in the school institution, mentioned the date of joining to be
My lord,
10/4/20.
I have to abide by the head of institution. In fact, my lord, in page 49, I submitted the FIR, my lord, prayer for that, my lord, FIR was before the SP in Nalbari, my lord.
Keep on prosecuting that, sir. This is-
So let them file the affidavit so that they,
Mr. Gupta, that secretary. That is order to 36, 30% must be done in W 5/9. The petitioner, the applicant that initially joined the PC Hindu Dutta that secondary school on 4/4 as a computer teacher. Subsequently, she resigned from that post and later on was appointed as subject teacher in Assam by appointment letter dated 5/4. According to the petitioner, he had joined the post of subject teacher on 6/4/2010 and was serving at effect of 2010. However, on the instruction of the principal of the school, that is the respondent number 5, he was asked to submit one more joining letter dated 10/4/2010. Subsequently, the authorities had determined the interested security between the appellant and the respondent number 6 by taking note of the fact that the date of joining of both the subject teachers were 10/4/2010, as the respondent was senior in terms of age. Agreed thereby, the appellant had contributed to the anomaly in determining the senior. Earlier, in terms of an order dated 13/6/2013, asked for the single judge in the Director of Secondary Education has gone into the question of date of joining of the applicant and the response of the seeker, thereby help that both the candidates' date of joining was 10/4/2010 and accordingly found the response of the senior by calculation of date of birth. Active thereby the subsequent detail which was also it was a displacement by the order. Mr. Goswami has advanced argument that the finding of the director not correct and there were evidence that the applicant had joined earlier. However, there is no material available for record first that the prosecution of Mr. Majumdar has also submitted that the contemporaneous record including the attention were missed. To reverse the finding, we would have to arrive at a conclusion that the finding is further. It cannot attest that convincing and cogent materials. No such material. If the petitioner is inclined to pursue her claim of oral evidence, then this in view of the reasons cited, we do not find it that the appellate, however, that the person
Number 25.
This is an appeal by the state, my lord. Selling an order of the learned civil judge, my lord, passed in the petition and thereafter in the review petition, dismissing the review petition. One of the grounds of appeal are that, my lord, the petitioners who were appointed in their
Yes, carry on.
No, the petitioners, they were appointed in their schools after the schools have been provincialized by the managing committee of the schools. Now, the managing committee did not have any authority to appoint such teachers at that point of time. Later on, my lord, there were orders to show that their services had been regularized under the government, my lord. Immediately after issuing of the regularization order, those order was kept in abeyance and their salaries were stopped. And it has come up in inquiry, my lord, that the very DOs who were supposed to have issued those regularization order had in an inquiry denied issuing those regularization order, my lord.
Sir, have you terminated that service
My
by
lord,
adopting the due process of law?
my
If
lord,
not, can you withhold the salary?
my lord, if the regularization orders were not passed by the concerned department, would they be,
There
my
has
lord?
to be a formal order.
So those
stating that the
orders,
orders were never passed.
my lord,
They are not a part of the record.
my lord, they have come up in the inquiry, my lord. Everybody has denied issuing those
It's very
orders.
easy
my
to
lord.
pass the buck. Any such order, formal order by the government, they are, as per the orders, regularization orders, they are regular employees of the state of Assam.
My lord, those regularization orders were itself taken, fabricated, and could they have been,
Any criminal prosecution?
my lord, yes, FIR was lodged.
What happened?
A final report had come up, my lord, which we did not accept, and we were given the.
As on date, there is a finding in favor of the teacher.
My lord,
Even the criminal case has registered, resulted into a negative final report.
my lord, which has not been accepted, and the court has rejected the final report, my lord.
Irrespective. As on
Court
date,
has
there is a
rejected.
concluded finding of your own agency. It is not the petitioner's agency.
Our departmental inquiry has led to a conclusion that those orders were fake.
How do we decide
were-
that, how does the court decide that the orders were fake?
And my lord, at the first go, my lord, they had to show that those orders were a part of the records of the government.
Why were they supposed to? On
My lord,
whom is the burden?
The
Who
very
is
orders,
stating that the orders were fake.
my lord, when they stated that the orders were issued, those order numbers were never there in the DO office. We had brought it on record that they were not issued by the office of the DO.
The way out for the government
My lord,
was to get them prosecuted for fraud.
but that is what
and forgery.
we lodged an FIR regarding fraud and forgery
And
when
then
we,
again, the investigating agency is your own organ.
yes, my lord.
And that too has resulted into a final report.
But
Then what
that
remains?
final report has not been accepted by the court, my lord.
Maybe so, as on date, there is
So therefore,
ample evidence to show that the police even doesn't find your allegations to be credible,
my lord,
your own agency.
the person who is required to sign the document, who has issued the order, denies issuing that order, my lord.
Nice. Are we going to record evidence here?
No, my lord, not,
Is there
not,
an FSL report?
my
Did
lord,
the police collect handwriting?
my lord, then the police collected handwriting.
What
We have,
happened?
that handwriting was not collected from the office documents. That is,
The handwriting
there is an-
expert's report is against you.
because, my lord, those
Now
documents,
we have seen not in one
the
file,
official,
the officials, if they are put under the scanner,
my
they
lord,
immediately try to take an avoiding stand. We never did that. That is very easy to say.
my lord, even the issue registers do not, the numbers do not tell you the government orders which were said to be of regular.
Council, once the police finding is that the orders were signed by those very DEOs, there is a cause to prosecute them for fabricating those documents or providing employment to these persons.
My lord, police,
They are not at fault.
my lord, police, even if the police has refused to prosecute them, we have been given the liberty to proceed in a complaint case against them, my lord.
Difficulty. Have you initiated any department?
My lord,
those DEOs?
The informant at that point of time, who was the informant at that point of time, has retired and processes on to have another official initiate the complaint proceedings on the very documents that they had produced, my lord.
Just absolutely unwarranted.
My lord,
There is no termination order. How can you without that?
that termination would have come if the order, if they were our servants, my lord. Had they been the government servants, my lord. If they are not government servants, even on record, my lord, the issue of terminating them would in fact give them the benefits of the past service.
They are employees of Madrasa.
They were employees of provincialized schools. Provincialized schools are those schools which were private at one point of venture schools, was taken over by the government. Their appointment was after taking over by the government, by the managing committee of the school, my lord, which,
But the regularization order was passed by the government.
my lord, that has been denied all the while, my lord.
Please don't even refer to that.
That orders were never passed by the government, my lord. They were not passed by the government. That is the whole issue, my lord.
That allegation is again now a disputed question of fact. Rather, it's a concluded fact against you after investigation by police.
Police not being able to, my lord, accumulate
Then
some.
what is the move to find out that the regularization orders were fabricated?
We'll have to proceed with the complaint case, my lord. But if prior to that, the honorable court holds that those regulation orders are correct, we will have no.
At least have that liberty of proving your charges in the criminal case. If you succeed, you might very well think of deciding those regularization orders or passing an order that the orders were paid and so they are not entitled to continue in service.
But in the meantime, my lord, their arrear salaries for service not
They have
rendered
to
under the
pay.
government.
They have to
The salary which is for a
Take
period.
an order from us and the things are finalized. Nothing remains done. You already have an order against you.
We do that, my lord. We have that order against us, but that is the order which we are trying to, my lord,
Get
say.
it confirmed.
my lord,
Now on your statement, rather the respondents have filed that final report on record, we suppose.
my lord, the final,
This final report is
Final
there.
report, your lordship will find, my lord, at
Yes, we
page,
have seen it. 1247,
yes, my lord.
page 247.
And my lord, thereafter, a Naraji petition was filed, that has also been rejected.
That has been
that is,
dismissed.
no, that has not been rejected, my
That
lord.
has been rejected.
No,
That
my
is
lord.
not-
The complainant is at liberty.
Yes,
Appeared
yes,
before the
yes.
court, by petition number so and so objected against the FIR and wants to proceed with the case, peruse the record. Considering the petition number so and so is rejected, the complainant is liberty to file the CR case.
Yes,
247.
file a complaint case if you want. The FR is accepted. No what remains.
My lord, in that case, my lord, the holding, the finding that the orders of regularization were correct or that, my lord, that would
Now
go
that is
against the
a
whole
concluded
criminal case,
fact,
my
sir.
lord.
Nothing remains.
I would lordship have it on the next week, my lord.
For what?
I'll.
For what purpose? Dismiss.
I'll your lord.
All right.
Item number 27.
May I please, madam?
Yes,
May I please? My lord, the facts which led to the filing of the writ petition
no
was,
one for the respondents.
well, the government, my lord. The government would be there. By the way, you are there, no? My lord, the facts which led was, he was a data entry operator. It was an ex-cadre post, but
Lordship, yes, there are separate standing counsel for the SAD department, Lordship, and as well as for finance, Lordship. That's why I'm just, if
Trying
it
to
can be
find
taken
out
up
who is
after some time, Lordship, I'm just informing.
they have exceeded the individual jurisdictions in this matter. my lord. After the pay commission had recommended, cabinet had accepted.
Let the respondents be
Lordship,
represented
Lordship, Lordship,
properly.
Lordship.
Madam is at a loss. Who is to argue the matter? We'll take it after a week. In the
Lordship,
meantime, you complete your instructions. Who is to appear
Lordship.
after 1 week?
Number 28 and 29.
Lordship, I may be allowed 1 week's time to serve copy of memo of appeal to my partner, Lordship. In item
And
20.
counsel, shall raise for, shall provide copy of the appeal
Lordship,
to the counsel representing the respondents within a week.
Lordship.
Please thereafter.
Number 30.
None present for the applicant, rest after week. None present for the parties.
Number 31.
May I please, Lordship? No, this is preferential appointment matter. The impugn order is page, my lord, 91 to 95, annexure 17, my lord. My lord, due to lack of my medical report, my lord, that writ petition, earlier writ petition was dismissed, my lord. My lord, the petitioner father, he was injured in the year 1983, my lord. Appellant is the daughter of the victim, my lord. Then in pursuance of Assam preferential appointment 1999, my lord. She is entitled to get the preferential appointment, matter. Appellant applied 2 times, my lord, annexure 11 to 13, the advertisement, my lord.
Where is the medical evidence to support your claim, sir?
My lord, page 26, annexure, my lord, 6, DC certificate, my lord. And annexure 5 is the certificate issued by the ASU, my lord. Page 25, 24, 25, my lord. Petitioner, appellant's father was bullet injured, my lord.
Where is the medical report, sir?
My lord, medical report was not
So
here
then,
in the document, my
simply
lord.
on the basis of
Only
certificate
due
issued
to
by
my-
the ADM,
My-
or when did he receive the injury? What is the date, precise date, let us know.
Melody in the year 1983, Melody ASU certificate is
3 is
released, my
12
lord.
months, sir.
My
There
lord.
should be a date. Bullet
Can-
injury,
can-
person receiving bullet injury,
My lord,
you would
kindly,
require,
mildly kindly see page 24 to 25, my lord, page 24 is in the. And in the details of victimization in the last line, my lord, it is injured on the bullet
this
of
document is
CRP at,
issued by all Assam Students
my
Union.
lord, my lord.
This
my
is
lord.
not a government document.
And then there, my lord, page,
And then again, the
page,
document issued in 1989 for an incident which took place in 83.
my lord.
This is nothing but a fabricated document,
My lord,
nothing except that.
Annexure 6, page 26, DC certificate, my lord.
This is to certify that Sri Kamal Saikia of village town Kotabua, PS, Rupohihat, subdivision, Sodor, district Nagaon, was feel physically disabled injured in connection with his participation in the Assam movement of the problem of foreigners, and that Srimati Soyanika Soikia is the daughter of the
So
injured.
does this certificate say that cause of death of Mr. Kamal Saikia was that bullet injury?
Yeah, also certificate reveals that when he was bullet injured, but in the
Sorry, sir. Dismiss.
appellant applied for two posts, one physiotherapy and another is for
There is no question
health
of
and family
entitlement under
welfare.
this statute.
My lord.
She may apply when a regular recruitment process takes place. There's no question of preferential treatment.
My lord,
She has to
appellant
go for the
only
government
prays for,
jobs.
my lord, appellant prays for only for preference in case of appear in the interview, my lord, and
Sir, what
selection, my lord.
should
Kindly
we
be
give
considered, my
preference?
lord. Otherwise,
She has to apply as any other ordinary candidate. No specialized treatment. Thank you. No merit dismissed.
Item number 32.
No, I'll take it. All right.
May I please? Lord, this is a writ appeal against the judgment and order of the learned single judge. The judgment will be at page 175.
170, sir.
175. It starts at 170.
Yes.
Lord, it was a case that the petitioner has qualified to the Assam Public Service Commission and thereafter appointed. Thereafter, the complaint was that she has said that she is a OBC candidate. In fact, or allegation, in fact, she is not OBC. So what happened, my lord? It is an intercaste marriage between her father and me.
What
Pardon?
right does the Anti-Corruption Liberation Union
Yes.
have to question the appointment of a public servant under whatever capacity? Is it a PIL or what?
It is not PIL, but
Then, sir?
my lord, what happened?
It is her individual right. She has challenged by filing a writ petition.
It is petition because
Yes. Even a de facto complainant can't be a necessary party in writ petition. That is what has been held. Assuming that the criminal prosecution may have been initiated on your FIR, but can you be a necessary party in the writ petition? It is the right of the respondent writ petitioner
Yes, correct.
with the government.
Yes, correct. You have been implemented as respondent number 7.
Maybe, sir, maybe. To our mind, it was not required to impede you at all.
My lord, I have stated that. Kindly come to page 130.
Yes, please. 130?
132,
Yes, please.
paragraph 12. May I read it, my lord?
Yes, please.
That while denying the statements of our affidavit and averments made in paragraph 10 of the writ petition, the deponent humbly states that Anti-Corruption Liberation Union is a joint platform of 5 different students' union groups who represents 5 different communities of Assam. All these communities are all under the category of OBC, and it has been constantly working for the upbringings and uplift of the socially and economically deprived people.
So that's
of the-
what we observed, sir, that you are trying to act in public interest. That is what your action is, that in public interest or in the interest of the unions you are representing, you are trying to espouse public causes. Then how are you required to be heard in a writ petition involving purely a service dispute of an employee?
The question came, my lord, that OBC, they claim that they are looking after the interest of the OBC, SC, ST. Suppose this position, this post is vacant, the next OBC will get.
That is all right. So that next OBC candidate, he or she could have challenged their appointment saying that the OBC status which the petitioner claimed
That's
is not
true.
correct.
That's true, my lord. I am not challenging that. But here, everybody inquiry is made, orders are made. And there are 2 orders. One is inquiry and one is by the
Yes.
speaking order passed by the authority. The inquiry report is against us and the speaking order passed by the authority, that is in our favor. The learned single judge has only
It
looked
was
in.
not an order in your favor, sir. It may have been an order affecting the right of the employee to be appointed on a government post, but you can't claim that that was an order in your favor because you don't get any advantage of that order.
Nobody has raised this question earlier, not even the government. So, your lordship may be true on that condition, but here there is none to question them. They have been doing that and government also acted on that. And they have been made party
Yes,
right from the beginning.
true.
So on their petition, inquiry was made, then the authority passed the necessary order, which was challenged by the petition.
Yes.
So this question was not raised before the learned
If
single.
at all anyone was to challenge the order of the learned single bench, then it was the state. What is the stand of the state in this case?
State has, I am appearing for that candidate, but before the learned single judge, state had considered the case. It was state from the records who pointed out that the vigilance officer has found the allegation to be incorrect. And once vigilance officer's report is in favor of the candidate, according to my lord Madhuri Patel, they cannot progress further. Because Madhuri Patel is an self-contained code in itself regarding my lord how this aspect of the matter is to be considered. And moreover, my lord, this repetition, there is gross appeal in this gross suppression. Earlier, they approached this honorable court, my lord, filed one writ petition and PL all were dismissed. This has not been mentioned in
Why
the
was
present.
this not brought to the notice of the honorable single bench?
No,
You ought to have done it, sir.
no, we could lay our hands on the now.
Okay, later.
Yes. First
Same matter.
petition,
Yes.
first petition, my lord, this writ petition was withdrawn. Then a PIL was filed at page 7, page 9, lordship will find that PIL, my lord. This PIL has also been dismissed.
Oh. So you would
Paragraph
be-
4.
we can speak aloud. You
No,
would
my
be
lord, I have no knowledge about it.
drawing
Your lordship may give me some time.
significant
Let me,
cost, inviting cost.
no, my lord, let
You
me
can
give
have a
time.
look at it. No need to adjourn it, sir. The orders are there.
No, my lord, whether the same
They are-
party have done.
Just please have a look. at
Same
it.
party, same party.
Same party. Monsoon Barakoti is a party. That is why the first question we put. What is the locus? If at all you had to go in PIL, you have already tried that and lost.
I'm sorry, my lord, I didn't know it.
Please have a look at it. We are passing it over. Then you take instructions what is to be done. Whether you want to invite cost or a simple graceful withdrawal would be enough.
So that's, then I may not go further, but I have to know about it. Why they have subject?
Please have a look at the orders. We are
Yes,
passing
no,
it
this
over.
is, I am not questioning this, but why they have not given us instruction, I must know.
Yes, you have to know it from your clients. You may do it after the matter is over.
Your
But
lordship
we are
may-
not adjourning it in any event.
No, that be so, I will not appear.
We didn't get what you said. What did you say just now? We couldn't hear.
My lord, if that is, they say they have
Please have
done,
a look at the orders plus, please.
I'm not questioning it. What I'm questioning, I'm questioning my client.
Yes, of
Why
course,
did you
you are
suppress it?
required to, you're required to do so.
Yes.
This
that's
is
why,
a
my
gross
lord.
suppression, gross suppression. Because initial perception we had that probably your clients could have filed a PIL saying that there has been irregularity in procuring OBC certificates, which they have already done. This is not an individual cause which your clients can espouse, which precisely you are trying to do now.
Yeah, Lord, Lordship may give sometime.
Same. No, no. It's very connected. In one of the- Yeah. Okay. Look at it. So now, what is to be done, sir?
Your Lordship may kindly give me little time.
Tomorrow? Let's have it tomorrow then.
Today at 2.
At 2. Very well. Maybe we might complete the board and there is another bench tomorrow, today at 2. So we'll have it tomorrow.
Letter number 33.
May please Lordship. Item 33 and 35 are analogous. Would your Lordship allow me to argue a 35 first?
As per your convenience, sir.
30. I have prepared a short list of dates for the convenience of the court. Ready? But the issue before your Lordship in this cases
Dala means what are the?
Dala means the Dala that we know in our local language, Assamese and also Bengali. They carry small items in this Dala and then sell it, madam.
Sort of ready.
My lord. And the issue before Lordship is very simple, madam. These vendors, they were there pursuant to an order of allotment since for about 40 years, madam. Now, from 2000 onwards, there have been the railway authorities have been framing catering policy. In the year 2003, my lord, they suddenly enhanced the no.
Basically, you are saying that you are operating the stall
My lord.
under licenses issued by the railway.
Absolutely. This is an
Licenses
admitted.
cannot be perpetual.
No, but
If there is a change in policy,
my lord.
your licenses have to be in accordance with the conditions
My
of the policy.
my lord, to that matter, I've got 2 full submissions.
Yes.
One, these policies which in subsequently will not apply to me. This is what the Honorable Supreme Court in a similar matter has said. I'll rely on that 2016. I've got the judgment. Secondly, my lord, the allotment which was issued to me at the time when I was allotted, that also contained a renewal clause.
Yes, but the renewal is not as a matter of right.
My lord,
The licenses can't be indefinite for an indefinite period.
my lord,
It is now a question of procurement by public advertisement. So everyone has to compete. It is not as if you are tenants of the railways. License You read the conditions of the license.
My lord.
Can't it be terminated?
It is, my lord.
So then,
My lord, they have not terminated. In this case, they have not terminated. What they have done is, my lord, Lordship, can you bear with me for a moment?
yes, please.
2003, my lord, they have enhanced the rate by 12%. That we challenged initially in a writ petition. The Honorable Court said that in the agreement, there is
Arbitration.
an arbitration clause. Finally, we were relegated to arbitration.
Right.
Award was against us. But it said that it will not have any retrospective effect. Prospectively, you will have to pay. Ultimately, my lord, we filed an application under section 34 that was decided. 37 appeal was pending. At that stage, my lord, there was some negotiation also. Then we paid all area in terms of the award. That payment, my lord, they have received till this month, my lord, February 2023. And my lord, they have not terminated our agreement. They have not, my lord, cancelled the allotment. Now,
The licenses are term specific. So if they don't extend it,
my
there's an automatic termination.
well, that is in my humble submission, my lord, there will not be any automatic termination because renewal clause says if your performance is satisfactory, we will renew it. Lordship, may I kindly have a look at this, my lord.
Yes,
Page 40 of this memo of appeal, my lord.
yes.
Clause 31. If the Lordship has got, my lord. The renewal, Lordship has got, my lord.
Yes.
Page 40, paragraph 31. The renewal of the agreement shall be dependent on satisfactory service of the contractor having regard to all binding of this agreement and at the sole discretion of the administration, and the contractor shall have no right to claim the renewal as a matter of right, as your Lordship has indicated. But then, so long as my performance is not found to be dissatisfactory, my lord, there is no automatic termination or cancellation of allotment. Now, what they have done, my lord, they have while the enhancement litigations were going on, my lord, arbitration, etc., they first issued a notice on, my lord, 26th of August 2014. Lordship, may kindly have a look at this, my page 85.
85.
Page 85.
Yes.
They say it is seen from the records available in the office of the undersigned and that you are unauthorizedly running one stall for selling of drugs and cosmetics in platform number 1 in Guwahati railway station since long. You are therefore requested to submit if there is any relevant document is available with you in this regard within 10 days from the date of receipt of this letter. Otherwise, suitable action will be initiated. Then we filed our reply, my lord, and thereafter we filed our reply. All these are annexed, my lord, here. Then they have issued another letter at page 104, my lord. 4. Page 104. Your reply of this office letter, even number dated so and so, is not satisfactory by the competent authority, and the relevant documents which has been submitted along with the appeal are also not valid documents to run the stall at Guwahati railway station. Instead of those, if any valid documents is available with you to run the stall, please submit the same to this office within 7 days from the date of receipt.
Why does not? Why does? It's here. In that case, the only argument which is required to be considered is that the catering policy of 2017 does not apply to your clients. How do you substantiate that?
My first submission will be when initially we were allotted, there was an agreement. Agreement provided a renewal clause, and whether this 2017 policy will supersede our agreement between the parties. We both the relationship is
As you said,
governed.
the agreement is just a license. It is dependent on renewal.
Yes.
They exercise their power of not renewing, and then they initiate the process of their as provided in the policy of 2017.
My lord, your lordship is absolutely correct in saying that they have to go by the policy. But the question is, my lord, when the parties are governed by the terms of the agreement, and agreement says that if my service is not, if it is dissatisfactory, if they are not satisfied, they can terminate. That action they have never taken. They are simply saying that you do not have any valid document. My whole submission before lordship is, my lord, when admittedly there is an allotment and we are there for last 40 years, and we have been paying license fee.
Any particular order of renewal you can point out, sir?
No, renewal has not been done. 2005, we applied for renewal. That application has not been dismissed by them as yet. In that view, the matter, my lord, whether they can straightway say that you are existence is unauthorized.
Compete in open tender, sir. What is wrong in it?
And my lord, these two documents which they say invalid, you have not been able to produce the document. My lord, allotment letter itself is the permission based on which I am occupying this and operating my stall, my lord.
Where are you referring to? Where is the allotment letter?
My lord, will find at page 26, my lord, onwards. There are 4 petitioners, my lord.
Yes.
26 onwards. 26 is the first marriage of 76. (26, 30, 31, 51) in respect of all the 4 petitioners, separate allotment.
It's all right, sir. So now, what is the ground for arguing?
My lord,
that
my
the policy does not apply.
my lord, my first submission will be, my lord, I'll be relying with that Supreme Court judgment which says, my lord, in a similar matter, my lord.
Next, first.
At 2000, I'm relying on 2016 volume 3 SST, page 582. And a similar issue came up here. Earlier, there was a policy, catering policy of 2010.
Yes.
And subsequently, 2017 policy was framed. And pursuant to the earlier policy, since their license was renewed, and in pursuance of the 2017 policy, they floated tenders. Those were challenged. Those were challenged before the Supreme Court, and the Supreme Court was of the view that no, 2010 policy will apply, 2017 policy will not apply. And Lordship may kindly see para 4, my lord.
Para 4.
My lord. Agree with the respondent association members of which had existing licenses filed a writ petition before the single judge High Court of Judicature of Andhra Pradesh, Hyderabad. The respondent association urged that the said action of inviting fresh bids is discriminatory and also contrary to the provisions of the catering policy 2010. The main plea of the respondent association was that in terms of the catering policy 2010, the existing licensees were entitled for renewal of their licenses for a period of 3 years, subject to their satisfactory performance, payment of all dues and arrears and withdrawal of court cases, if any. They prayed that the appellant be directed to renew the licenses of the existing license holders of the canteens and fruits and produce stocks. The wide judgment it is so learned, single judge came to the conclusion that catering policy 2010 did not differentiate among the licensees based on the number of years for which they have been carrying on their business. It was further held that the under catering policy 2010, the license fee is liable to be revised based on the potentiality of each railway station and the turnover of the licensee during the previous year. Since the license fee is subject to continuous revision and does not remain stagnant, the question of railways suffering any loss due to renewals would not arise. The learned single judge held that the members of the welfare association are entitled for renewal of the licenses of the members subject to their satisfying the conditions stipulated in para 16.1.3 and 16.2.1 of the catering policy 2010. On appeal filed by the appellant, the judgment and order of the learned single judge was upheld by the division bench of the High Court in the appeals by judgment and restenso, and the present appeals are filed. And thereafter, my lord, this appeal by the railway authority was again dismissed. Lord, may kindly go to para 33 and 34, my lord. Concluding paragraph. 33
is the language of policy of 2010
yes.
and
Yes. 10 provides for renewal.
And 2017 does not
Doesn't
provide for
provide.
renewal.
It says there will
Any
be,
interpretation of that policy by any court?
my lord,
Any interpretation of policy of 2017 by any court?
my lord, I couldn't follow your lordship.
Has there been any interpretation of policy of 2017?
Challenging the policy.
Yes.
Yes, my lord. The second case is that. I'll come to that.
Yes.
Now, para 33 says, my lord, therefore, we have to hold that the provisions of catering policy 2010 are applicable to the respondents concerned. The action of the railways in not granting renewals of the licenses to the members of these respondents is arbitrary, unreasonable, unfair, and discriminatory, and the same cannot be allowed to sustain in law. For the reasons stated supra, this court cannot interfere with the impugned judgment and order of the Honorable High Court. The civil appeals are dismissed. The order dispense of granting stay of the impugned order shall stand vacated. We, however, make it clear that only those licenses may be eligible for renewal of their licenses who can declare on affidavit that they do not have the license of more than one stop or kiosk in their name or Benami license at the railway stations with theoretical reasonable increase of license fee, all pending appeals. That is true. Now, my only submission is, my lord, we have not been found till now to have performed unsatisfactorily. That being the position, my lord, you have to decide, take a decision on our application for renewal.
Yes.
That decision you have not taken.
In that judgment, the only issue before Honorable Supreme Court was
My lord.
that whether the licensees were entitled to renewal or not.
Yes, my lord.
Herein, now the policy says no renewal at all.
My lord, yeah, my lord, here in this case, although the challenge was to that letter whereby we were sought to be declared unauthorized, the Honorable Single Judge has again taken a decision that since 2017 policy doesn't provide for a renewal, they are at liberty. And taking that liberty, my lord, they have sealed our shops.
Right.
So ultimately, issue boils down to the issue.
Query again,
My lord.
that whether there has been any challenge to the policy of 2017.
17 policy we challenge, but this is the other issue, my lord.
Whether there is any judgment of any court, sir, that is what we want to know.
My lord, I have not come across any.
High Court has dismissed the challenge to the policy.
Let us see.
This is the other appeal, my lord.
That is a single bench judgment.
My lord.
Any other court or Honorable Supreme Court?
Three other high courts have considered the policy. In those cases, my lord, the policy was not under challenge.
Okay.
The prayer was for renewal.
Mhm.
The honorable courts, my lord, the High Court of Hyderabad, my lord, the Telangana and Patna, my lord, they have considered the 2017 policy as well as the 2016 judgment of the apex court. And thereafter, they have those courts have held that the renewal is no longer permissible. 2016 judgment is, my lord, to the particular facts and circumstances of the case only. After coming into force, the 2017 policy, my lord, the benefit of renewal could not be there. In fact, my lord, the clauses for renewal, my lord, of the licenses was there only in the 2010 policy. Since 1995, there has been various policies, my lord. In none of the policies,
But then you have been allowing them to continue business for 40 years, sir.
My lord, at
One
that,
fine morning, you wake up and say vacate the shops.
no, my lord.
That is infringing upon their right to livelihood
That is-
directly.
When they came in, my lord, there was no such system of, my lord, going for tender process. On applications, they were allotted the
Is
stock,
right.
my lord. And subsequently in 2005, my lord, when the licenses expired, we had written to them that, see, your licenses have expired.
But you have accepted the money thereafter.
My lord,
So there is a
February.
deed renewal.
my
In
lord, there-
February.
You have not passed the formal
Yes.
order of not renewing their licenses or of taking steps to evict them.
my lord, there were orders from the court, my lord, that's why I could not, my lord.
No.
Those orders must have been passed now when the writ petition.
Other thing, my lord, so far as the deposit of, my lord, the license fee is concerned, I've spoken to the authorities. They told me that, my lord, these fees, my lord, they deposited in the my ticket counters, my lord. So these authorities, they are not aware of, my lord. They came to know subsequently only.
Mhm.
They go to the UTS counter, my lord, and there they make the payments, my lord.
Do that.
Fact remains
That
payment is
that is
made.
how the payments are made, my lord. That is how the payments are made.
Yes.
You have
The
received-
counter wouldn't accept any random payment, sir.
But anyway, my lord,
That's a futile argument.
anyway, my lord, the 2017 policy says that the earlier policies have been superseded, my lord. It's,
All right, so let us see the challenge to the 2017 policy
Mal-
first.
That was issued by IR. I am appearing for IR.
Okay.
Earlier, my lord, the allotments were given by the railways.
Railways.
Railways, my lord. Now ICTC has come, my lord.
Well, IRCTC was for a specific period. Now they are no longer there. They were from 2006 to 2010. Again, it has come back to railways. Factual parties like this. My learned senior colleague is not aware of it. Now IRCTC is not there. After 2021, they have gone.
IRCTC is very much there, sir.
No, my lord.
Not into catering on
It is their
stations.
document which shows that it is now, it has come back to the railways. Units, these vending units have come under the
The railways.
Railways.
What
Well,
material?
this document I'm showing, even they themselves have issued that there will be renewal after this Supreme Court judgment. They have referred to the Supreme Court judgment here.
No, this is this argument.
My lord,
If
I
this is
Yes.
holding water, that the IRCTC is no longer handling the
Yes.
allotment of stalls. Then
No.
not that, my lord. The IRCTC, my lord, is doing everything, my lord, now.
It
what
is in
what is
their-
the basis? What is the basis of sitting?
It is there in their affidavit, man.
Oh, let us see.
Well.
It is in this validated petition.
Possibly, man. I'm just saying, yes. The affidavit in opposition, they have filed, my lord, is at page 112, my lord.
Replacement roof, sir.
Yes, sir. Yes, please read.
My lord. And
Which
my lord,
para you are reading, sir?
my lord. I'm sorry, but it is not there in.
This is not the affidavit on behalf
but
of
there is-
IRCTC.
Huh? But it is an admitted position, my lord. It's
Sir,
after
please,
2000.
from where you
My
are
lord.
saying it is admitted, Learned Council
My lord.
from the IRCTC doesn't accept this
Hmm.
proposition.
My lord, the 17 policy, page 181 in the first.
In the other first appeal.
First
Yeah.
appeal, my lord, because I am appealing in that case only. The second appeal, I am not there, my lord, because IRC is not a part.
Page number
181, my lord, that's the policy.
131,
181,
181.
catering policy.
So can you get instructions on this statement that IRCTC is no longer handling the catering part on the stations?
The catering, I
After
will,
2010.
they are
To the
saying only,
extent-
my lord,
To the extent vending part IRC, vending
my lord.
contracts and everything, then the entire controversy would change the entire nature of the controversy would change. Can you take instructions? When?
My lord, in fact, for a few days, I shall not be here, my lord. Let it, on
Please
Monday next.
let us
Monday
know.
next.
Till then, let them operate.
My lord, it's a livelihood, my lord.
Also been closed, my lord.
No, they have sealed after the single judge's order, my lord. Taking it, my lord, the honorable single
They
judge
were
has given a
operating
handle to
all
them.
through.
My lord, the licenses have expired in 2004 itself, my lord, by
You allowed them to continue till 2022, sir.
What? At two, my lord,
Overnight, you ask a person, you will not
at two.
at two, all right, come at two. If this is the status that IRCTC has no longer got control over these pending stalls, then you have to fall back in the original position, 2016 judgment would hold the field.
Well, I also point out, mine.
It should be there after that.
Deeply above.
Item number 34.
Please. I am challenging the judgment and order dated 2/11/22, whereby the appellant has been denied of the pensionary benefit. The scale of the pay in the post from which she has retired.
Lordship, this matter, Your Lordship, I'm appearing for the private, I'm appearing for the respondent, EAD. Here, Your Lordship, our name has not been reflected, nor has we have been served any copy, Your Lordship. in this matter. For the dependent administration. One copy there. EAD, setting of the setting. They have not given us copy, nor has it been reflected in the list.
Copy has been served with the government office, but now saying for this department, they are pending.
Standing on.
Government is, but the deputy commissioner I am representing, they are
For the respondent number
for
one.
respondent number one.
All right, kindly serve the copy.
Yes, sir. I'll be- And that, yes, sir, during the course of the day. Going for 1 and 2. Yeah. EPM.
Number 36.
Can we take an up, my lord, Friday next?
Next, right.
Metro, my lord, maybe taken up on the Friday next month.
Third March you want. Next Friday, no? Or this Friday?
My lord, coming Friday, my lord, there is 24th. right? Third of March. EPM. Okay, sir.
Number 36.
Please your loss, man. My lord, I am agreed by the order of the learned single judge. The point here, my lord, to be decided is regarding Baki's clearance. It is a fishery matters, my lord. Fishery matter, Baki's clearance certificate was not updated. So on this premises, the learned single judge.
This is something.
Yes. My lord, our whole case, our price was much more higher than the private party. Where-
Provided to rule 12.
I'm sorry, my lord.
Matter comes under provided
Yes,
to rule
yes.
12. There is
Yes. So Baki's clearance certificate, my lord, what the learned single is the author who decides, the employer. Now there is a judgment of this coordinate bench where it said, where it has been stated, I have annexed that, my lord. It cannot be termed or construed as an essential requirement. It can be construed as a subsidiary or ancillary, relying on a judgment of Podar Steel, my lord. And there are a number of judgments which have been passed. And another point is that, my lord, the coordinate bench of this court has passed an order saying if you have a no due certificate, it is equivalent to Baki's clearance certificate. Because ultimate no due certificate is a very important factor. But the learned single judgment are different. Now, in first order that has been passed by learned single judge, only next time a settlement is given to a third party. Now, I have made the third party as also party. Your lordship, now there cannot be a question of any interim order. A notice has to go to the third party. So your lordship will issue notice and will serve my lord notice to the other party. Two judgments of this coordinate bench I have annexed, my lord. Settlement response number 4. If your lordship permits, we can take a justice service also. Justice in addition to the. Simply apply.
Finally applied. Chapter number 37.
Please your lordship. Lordship, I'm aggrieved by the learned single judge's order whereby my writ petition was dismissed. This matter relates to the settlement of a LPG godown. I was given a letter of intent to set up the LPG godown on 24/10/2014, and I was given 2 months' time locate the land and set up the. Obviously, I did not find the land. Thereafter, I found the land actually, but ultimately the permission to construct was refused by the authorities because it was on a residential zone. There, and I informed the IOC. Thereafter, on 11/8/2017, that's about approximately after 3 years, I was issued a show cause notice by the Indian Oil Corporation asking me to show cause within 15 days why I have not found the land and set up the go down. I replied on 14/9/2017, where I said that I have arranged an alternative plot of land. And on 12/1/2018, I informed the respondent that I had taken a land on lease and I have already set up. I'm making plans to set up. And a lease deed was also forwarded. Thereafter, Lordship, after I got my land on 15/3/2018.
Are you seeking an interim relief?
Interim relief in the sense, they have not started the process yet, I think. So Lordship, a short date, I don't mind if notices issued with a short date.
My lord, a letter of intent was issued way back in my lord 2014. This is a setting up of a LPG code, not a LPG, my lord, dealership. Now we are in my lord 2023. The petition.
Basically, it agrees on account of the fact that they.
Absolutely, and Lordship, they have the power. They cannot arbitrarily cancel this. The rules say that, well, I have got my land. Lordship, they have not started the process, so I'm open. It's all right if I get to know it.
All respondents are represented.
Yes.
By you, sir.
Yes, yes.
The notice, there's no requirement of putting a formal notice.
No formal notice, I think not necessary. He'll probably need an extra copy.
Meetings are complete before lunch, single bench.
Yes.
Matter is to be decided only, already decided.
So Lordship, I fix a date, any date convenient.
Whenever both of you want.
Any date convenient to your Lordship.
Sometime in March.
Sometime in March, after Holi. Sometime
14th of March.
14, I'll be back on the, let it be on the 16th of March, Lordship.
Very well. 16th March. Department.
All right.
Obliged, Lordship.
Item number 38 for orders.
May I please, Lordship, I was directed to serve notice to the stay on the respondent, Lordship. Lordship, I am awaiting a response from the client. Lordship. Lordship, actually, I contacted the counsel. He said that he doesn't know about the whereabouts of the petitioner as well as the respondent. Lordship, allow me 2 or 3 days time. Abort was granted, Lord.
The peremptory order, sir, that you have to show to the court that payment has been made.
Lordship, as well as regarding Dasti service, Lordship, allowed 2 days time. Whether because I could not make contact with the client also.
That is what the time was granted to you, sir. Under the circumstances, we give another opportunity to the appellant
Lordship,
to take steps, failing which the matter will be dismissed without any further order.
Lordship, Dasti notice has been issued by the registry that has been sent to the
Further
client.
direction is appellant has to show before this court that he has paid rupees 2 lakhs out of rupees 4 lakhs to the respondent, which had been directed to be paid by the court below as permanent element.
Lordship, till date, I have not received any communication from the client. Lordship, may take up day after tomorrow, Lordship.
Counsel to the appellant prays for time to complete his instructions as to whether the order dated 17 January 2023 has been complied with. List on 28.
Lordship.
Item number 39
May I plead your lordship? Lordship, kindly, last chance may be allowed to take step, lordship.
Yes, please.
Lordship, kindly, last chance may be allowed to take step.
Your name,
Please,
please.
Gogoi.
Let's go with that. Quality.
Highly obliged.
Item number 40.
Please, your lordship, lordship, with apologies, my lord, I was not the counsel earlier, but I have seen that some documents are missing in the memo of appeal. May I be given some time, my lord, to bring them on record, my lord? My lord, it was restored thereafter.
It has been restored, ma'am.
My lord, the earlier set of counsels, my lord, the lead counsel was unwell for quite some time, my lord. Therefore, the matter was not pursued for some time.
What about that?
Bring certain documents on
How will you
record.
bring it by affidavit?
By it. Good, ma'am.
Item number
Keep your-
41.
May I please, your lordship? Lordship, I am appearing for the respondent number 3 in this case, and we are in the process of filing an affidavit today itself, lordship.
That was the statement made on last date of.
No, lordship, last day, there was some correction required in the earlier order that was made on the last day. And as soon as the matter got listed, I prepared it, it is signed, it is being filed today, lordship.
Have you complied with the order?
Yes, lordship. Yes, lordship.
No, never. Not compliant, my lord. Kindly see, my lord, my, my lord, contempt case number, contempt case of page 13, my lord, order of report. Order was passed on 26/8/19, my lord. The relevant portion, lordship, kindly see the page 14. Mr. Dishokia has submitted that the government is taking necessary steps to evict the encroachers, and by following the procedure, land will be duly reserved for a children park, and therefore thereafter the plot of land will be converted to a children park. He also submits that the state respondents will ensure that there is no further encroachment over the plot of land in question. In view of the above, the public interest litigation is disposed of with a direction that the respondents will take steps as indicated in paragraph 3 of the affidavit in opposition filed by the respondent number 2, and in terms of the submission made by Mr. Dishokia during the course of his submission today.
So let us have their affidavit.
My lord,
Let us have their affidavit. How they respond, let us see.
my lord, let it come on, my lord, Friday or otherwise, because they are filing affidavit without eviction. Eviction is not carried out. It is more than four,
Satisfy the court that compliance has not been made, then we'll see.
my lord. Let it come on Friday, my lord. Obliged.
Counsel for the respondent submits that he would be filing compliance affidavit during the course of the day. List on 2nd March. That's the day.
Obliged.
Item number 42.
Hearing for the railway respondents hearing, my lord. In this case, my lord, the challenge hearing is to a judgment and order dated 21/9/2020, passed by the Lanu single judge, my lord. In terms of the judgment and order, my lord, the letter of award was already issued to the successful bidder, my lord. And the period of contract is already over. So this matter has basically become infructuous. Lordship will find that letter of award at page 6 of the IA, my lord.
I have got it. Page 246 of the writ appeal number.
Let us have the file, sir. Just wait for a moment. Let's have the file, please.
My lord.
Item number. You are reading from
Writ
item
appeal-
number 33.
My lord, writ appeal 47, my. Question may kindly turn to page 246. It's an affidavit filed by the IRCTC themselves, my lord.
246.
246, paragraph 5, Lord Space got, my lord. Paragraph 5, I'm reading. Lord Space got, my lord. That the answering deponent states that IRCTC to provide better services was regulated by the catering policy of 2005, wherein according to the policy, IRCTC, the tourism and the catering wing of the railways was given catering responsibility for all trains. The rest we can see for the timing, my lord. Next page, Lord Space.
Next page. Catering responsibility was taken away from the IRCTC.
Yes, madam. From 2010. That it is pertinent to mention herein that in pursuance of the catering policy of 2010, the catering responsibility was taken away from the IRCTC and
But then you come to the bottom 5 lines of this para.
my lord,
Thereafter again in 2017,
my lord,
the government of India, while circular dated 27/2/17 introduced
my lord.
a new and revised catering policy.
Yes.
By which the major part of catering services
Yes,
was transferred to IRCTC.
my lord.
So your statement is not correct as a matter of fact.
My lord, IRCTC has got no role to play now.
This affidavit says otherwise.
My lord, may kindly ask, I'm sure they will admit.
Let us.
And
know
number
his
two, my lord,
stand.
one more relevant submission, my lord.
Yes.
In 2021,
Mhm.
ignoring the 2017 policy, they themselves have renewed the license of vendors like us with retrospective effect, my lord. Lord, may
Then you are
kindly
required to place these things on record.
I'll
You
place
can't
it,
take them by surprise. So what is your stand on this submission, please?
My lord, your lordship will see the policy itself, my lord.
Yes,
page
that would
181.
be okay. That would be better.
Page 181, my
No,
lord.
no, not like this. Let them file it properly. Page number?
Page 181 policy.
Yeah. Just one. Yes.
Number 1, subpara 4, my lord. IRCTC shall be responsible, your lordship, for catering services through mobile catering units, best kitchen, cell kitchens, refreshment rooms at A1 and A category of stations. Food plazas, food courts, train service vending, Janahar. All other catering units like refreshment rooms at B and below category of the station,
Yes.
AVM, milk trolleys shall be managed
So
by.
now the crunch would be, what is the category of station on which these vendors are functioning?
A.
It's A.
So by zonal railways, not
No,
IRCTC.
it is by IRCTC.
No, this will be by as per this policy itself, my lord.
We fall in category B, my lord.
Are you sure?
Lumping.
No,
Lumping.
lambing is secondary
Lambding, Guwahati.
A.
Lambding and Guwahati is there.
category.
Need to be sure in this statement.
My lord need to be
Yes.
clear.
A. My lord, that category has been mentioned in page 198. my lord.
198. So these renewals which you are referring to, sir,
My lord,
must be for category B stations.
yes.
So you need to complete your instructions because statement made by you is not correct apparently.
We fall in A1, my lord. We fall in A1. There's no dispute.
So A1 again, that is IRCTC.
Yes, my lord, subsequently they have been given. 2017 we are challenging. 2017 we are challenging because Honorable Supreme Court has also said that existing policies will be guided by the existing.
Right. That 2010 they have applied,
My
but now there is a new policy. What is the ground of challenge to the policy?
That's what I'm saying. We are not challenging the policy as such.
And if
What
you
we
are
are
not
saying
challenging
is,
the policy, you have to be governed by policy.
no matter what,
Policy does not cater to any renewal of existing licenses.
my lord, what I,
It's by open tender.
my lord, what will happen to the existing, there is no reference.
They will have to apply in open tender. That's what they have to do.
My lord, what will happen to the existing one? There is no mention in the 2017.
Nothing to mention, sir. Otherwise also,
My lord.
as we observed initially, licenses cannot be indefinite. The licenses are governed by the period of the license. If there is no renewal, the license comes out. There is a famous judgment of Supreme Court, Pawandas versus RSRTC. The moment license period comes out, becomes over, the authority can throw out the licensee. No right beyond that.
They have allowed us to continue till
Maybe, but that-
2022 March. and
Does
they-
that acquiescence
My lord.
give you a right to continue indefinitely?
My submission is yes. They have to consider our application for renewal, which we have submitted in 2005 itself.
Now,
They,
assuming that they did not do so and under that slumber you continue till 2021.
my lord.
But once 2017 policy is there,
My lord.
unless you are able to satisfy the court
Right.
that policy is bad in the eyes of law, you have to be governed by the policy.
If it's a matter of policy, I cannot submit.
Mr. Majumdar,
Fine.
what is the rights of your client?
My lord. My lord. My right is, my lord, when I entered here as a licensee, my lord, there was an agreement. Agreement provided that it will be renewed unless the performance is not satisfactory. There is no finding, there is no decision on their part that your performance is not satisfactory. That being the position, my lord, and the agreement having not been cancelled till date, the rights and liabilities of the parties are governed by the terms of the contract.
What is the principle? Are you saying it's a case of promissory acceptance?
Yes, my lord.
That is the pleading.
Pleading,
What is the legal principle
Well,
you are
we-
relying upon?
my lord, we have said that it's arbitrary. Arbitrary in the sense that when there was an agreement between the parties, then the agreement
Please
provided a
read.
renewal clause.
Para 3.84, 8.4 of the policy, 183.
180. Three point 8.4. IRCTC shall not outrightly outsource or issue licenses for provision of catering services to private licenses. IRCTC shall retain the ownership and shall be fully accountable for all issues pertaining to setting up and operation of the base kitchens and quality of food.
Then come to 3.8.2, come back a little bit.
Yes. Contracts awarded by zonal railways for kitchens, etc., with refreshment room A1 and A category stations, cell kitchens shall be reassigned to IRCTC on the same terms and conditions with sharing of license fee between IR and IRCTC in the ratio of 40:60 in all cases.
So now there is an end to the thing, sir. This is an era of open tender.
That is something I
You have
cannot
to abide by that.
do. We have continued, we have paid, my lord,
True.
at least,
Again, the question which my learned brother put,
my lord.
promissory estoppel, whether it would apply in case of change of policy.
Unless it is brought by a statute, it can apply. This is my humble submission.
Otherwise, this
If there is a
simply
statute, of
commercial
course.
ventures.
My lord.
Commercial ventures are governed by the policy which operates at the particular point of time.
My lord. My lord, one issue, my humble submission before Lordship is, my lord. The Honorable Single Judge has proceeded on the premise that there is a 2017 policy, it will guide. Now, one issue that has not been gone into is, my lord, if there was an agreement between the parties and that provided a renewal clause, whether that will
For
be,
that purpose, you would have to file a review.
my lord, facts are there. Facts are there. I'm arguing on the basis of the facts which are already on record.
Facts are staring in the face that the policy is there. Policy doesn't cater to extension of license. It's all to be done either by the IRCTC on its own level or by open tender process. So whenever the process is there, you have to ask your clients to compete.
And my lord, the document which I have just now given, 2021, they themselves have said that in terms of your.
See, in our own profession,
My lord.
lawyers sitting in Delhi, lawyers sitting in London, they are arguing the matters in all high courts,
My lord.
10 systems at a time. So that is competition. You have to keep abreast.
No,
There's no way out now.
I'm on a slightly different issue. They themselves have in 2021 renewed the license of a person.
Sir, that argument is beyond the record. There's
Well,
nothing on the record.
I'll bring it on record. Lordship permit me, I'll bring it on record, madam, because they themselves have ignored the 2017 policy.
Can there be any
and madam, that is in,
equitable relief against law? Because if they have done it,
my lord.
then that is against their own policy. Whether we are bound by that,
And
that
here-
action.
Here, subject to correction, my lord, my submission will be, if there is a statute, there is no estoppel against statute. But if there is a policy decision taken by them and not a statute,
Very well.
well, let me bring it on record, I'll argue that point, my lord.
Very well.
My lord. And it is pursuant to their judgment of the Supreme Court only, they have renewed. Ex post facto, my lord.
Let's see what is the terms and what are the terms and condition of renewal.
My lord.
After arguing the matter for some time, and counsel, senior counsel, prays for time, to complete his instructions
Right.
and to bring certain additional facts on record. List after. When do you want?
A week, my lord.
A week.
Would you lot to give me some fixed date when I will lot to scope is that
Whatever you want, whatever is comfortable.
3 months.
27,
3rd March,
29.
3rd March,
3rd March.
deep job,
So is item number.
33 and 35.
Well, in 35, I am not appearing, my lord, and 33 only I
Whatever appearance is marked.
am.
And till then, let them maintain the status quo, my lord. I'm not saying that I will enter.
We are ready to declare the judgment right now if you want.
As a lot.
May Lordship, I again apologize, Lordship. It is, AG is in the midst of an argument, Lordship, in the court number 12, Lordship. Let it be fixed on Monday, Lordship.
Very well. We'll have it on Monday. As pre-notify on 27. 27? You done?
I'll apply, sir.
May I please, your Lordship? May I please, your Lordship? My lord, this is a review application, my lord. On the basic condition, there are some important documents, my lord, at least one document, annexure 8, my lord, which could not have been produced before the court because petitioners are not aware. My lord, there was a policy introduced by the railway authority in order to absorb some staffs, my lord, working under various unions, those who are discharging the, my lord, administrative function. And ultimately, my lord, there are 3 unions. 2 unions were considered, petitioner was left out. Then number of litigation took place, my lord. Ultimately, the stand taken by the railway is that, my lord, petitioner was a review petitioner union is not a recognized. But my lord, annexure 8 shows, my lord, election took place in 2013. But as my lord, recruitment process, my lord, completed in 2010.
You're referring to document and page number.
Page number, my lord. Annexure H.
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 Page 244, your Lordship.
So this was not a part of your pleadings in the writ petition.
My lord, that was because we are not aware of this document, as a result of which, my lord, it could not have been placed on record. And it shows that, my lord, a policy was introduced to my lord, determine the recognition of the union.
What is the page number?
244.
244.
Last page. Last page. Yes.
How does it, how is this a ground for review?
My lord, Lordship, kindly see, my lord, they said, my lord, all along they took this stand that we could not qualify ourselves because we failed to take, my lord, secure the requisite votes in the election. Election took place in 2013, but a recruitment process completed in 2010. Therefore, my lord, recognition cannot be based entirely on election. Therefore, my lord, this document itself shows, unless and until modality is completed or finalized, my lord, there cannot be any new recognition. And the existing, my lord, organization will continue.
Therefore, we are not the new, my lord, union. We are the existing union. Therefore, my lord, once decision was taken not to, my lord, hold any election till modality is finalized. Therefore, my lord, there is no question to determine our status on the basis of election, which took place in 2013. But the recruitment process may not completed in 2010. And this document itself shows, my lord, this is the decision of the Railway Ministry. And that too, my lord, on consideration of our, my lord, bona fide claim and representation.